ladies and gentlemen. It's Philip Harris. This is the second of our LawBytes takeaways session for the construction industry. The topic we're going to be looking at today is variations, and we'll be looking at whether a contractor has to comply with instructions for variations and what are the consequences of a variation on price and timing. But for all of these things, really the golden message is look at the terms of the contract. We'll be looking at the JCT family of contracts, and the detail is in the contract. Don't assume that you know how it works. Always go to the contract. Usually it will be section 5 of the JCT family of contracts, and that will tell you what to do about variations. So just very briefly, instructions can be issued which are outside of the contract. So something may appear to be a variation to the contract, but actually it's a mini order outside the terms of that contract, either before the contract is made or possibly after practical completion. So watch for that. Is this an instruction under the contract, or is it another order outside of the contract itself? But basically, when we're looking at variations, the key is what is the scope of the works. The detail and the precision with which the scope of the works is defined will influence whether something's a variation or not. If the definition of the scope is general and loose, then it's unlikely to be a variation. If the definition is very precise, then any small change is likely to be a variation. So it was said once back in the old days, the Thatcherite period, that for a contract in Birmingham, the scope of works instruction was 4 points on the ground, go up as high as you can, because the employer just wanted to get his income stream out of that building. If it's as broad as that, hardly anything will be a variation. Another contract was perhaps foolishly let as a design and build contract, but it was for a dairy, and it had to be very, very precise in the scope because of the food and drugs regulations and all that sort of thing. So really anything, any tiny change was bound to be a variation because the contract was so precise. The next thing is to distinguish between variations to the contract itself, to the mechanism of the contract, from variations in the works which are instructed under the contract. Variations to the contract mechanism will usually be made as a deed of variation. But it's not uncommon that architects and contract administrators and employers' agents will try to slip in a change to the contract, sort of masked as a variation instruction for the works. So watch for that. If it's changing the mechanism for time, if it's changing the mechanism for valuation, then that is a change to the contract rather than a change to the works issued under the contract, under the variation mechanism of the contract. Next, we just want to distinguish between the traditional JCT contracts with architect, contract administrator, those people who certify and administer the contract in relation to time and practical completion and those things, from the design and build contracts, where you have an employer's agent, but there are different mechanisms. In a traditional contract, the scope of the works is, at least in theory, fully designed and fixed by drawings and bills of quantities, etc., when the work is let. In a design build form of contract, the employer sends out his employer's requirements, and the contractor, the tendering contractor, responds with a set of contractor's proposals, and at a point in time, the employer says, well, those proposals appear to meet my requirements. But then the design is not complete, and the contractor takes the unfinished design in the employer's requirements, and he carries out and completes the design. He carries out the works and he completes the design. If you are under a design and build form of contract, then it's only a change if it is a change to the employer's requirements. So for there to be a change, there must be a change to the employer's requirements. And as I say, the employer will usually issue his instructions through the employer's agent. What is an instruction? To have variations, normally they will be instructed. There can be deemed changes and variations, but normally they will be instructed. The JCT traditional and design and build contracts don't define instructions. If we look at 3.10 of the standard building contract, it says the contractor shall forthwith comply with all instructions issued to him by the architect contract administrator on any matter on which these conditions expressly empower him to issue instructions. So it's the architect who instructs, but he only instructs on matters where he is empowered to do so. And that's important. If we look at Hudson's building and engineering contracts, the Bible on construction, it says it cannot be too strongly emphasised that construction professionals, unless the contract gives their certificate or decision finality, will have no authority whatsoever to waive strict compliance with the contract or bind the employer. If an architect exceeds his authority, then he can be sued for breach of warranty of authority. So that's an important point. The contractor can sue him for breach of warranty of authority. Now, there's no implication in a contract that the work is feasible. In other words, the employer isn't saying, I promise you, Mr. Contractor, you can build this. And so sometimes contractors get in buildability problems. And then an architect, maybe trying to be kind, will issue an instruction for extra work to get the contractor out of that mess that he's got into. If, generally speaking, in that situation, the employer is not bound to pay any extra if those works would always have been necessary to achieve the job, to carry out and complete the contract. So architects helping the contractor out by issuing these extra instructions, that doesn't bind the employer, and he doesn't have to generally pay any extra for it. So then let's get on to the JCT family of contracts. And we have this big section in the contract. Section 5 is probably the biggest of all of the sections, which tells us all about variations. It defines what they are, and it tells us what to do with them. And the definition itself is the very important thing. So if you look at section 5.1.1 and 5.1.2, there are two distinct paragraphs that help us to define what a variation is. 5.1.1, the first part, is really pretty much what you would expect. It's the addition, omission and substitution of work, the alteration of the kind or standard of the materials or goods, and the removal of work which isn't actually defective. That's what you'd expect, adding and omitting, etc. The second part of the definition is the interesting bit, it's the fun bit. The imposition by the employer of obligations or restrictions on the following matters, and they are access to the site, limitations on working space, limitations on working hours, and the execution or completion of the work in any specific order. All of those things are variations, and you have to get your head around that. So you might think, well, if they change the sequence, so we were supposed to work, from the first floor up to the 7th floor, and then we're told to work on the 4th, and then the 6th, and then the 3rd. That's disruption, and I can claim loss and expense for that. But no, that's not what the contract is telling you. The contract is telling you changes to sequence, changes to working space, all those things, variations. So if you had a plant room on the roof and through a noise attenuation order, you had to put all the plants in the basement. So originally you had a plant room on the roof, a plant room in the basement. All the kit has to go down to the basement. Then you've got confined working space. That's a change. If the hours change, again, perhaps through noise attenuation, the hours have to be reduced. That is a change. And all of those things are measurable under the mechanism of the contract. So, and the best way to claim these things is to claim them as a variation, as a change under Section 5, and not try to claim them as loss and expense. If you try to claim them as loss and expense, you have to provide invoices from subcontractors, you have to prove your actual loss. If you're claiming it under the variations mechanism, there is a clear mechanism. There will be an adjustment of price, and two quantity surveyors on each side can simply sit down and make that adjustment. Also, we have deemed variations. So scattered through the contracts, there are these provisions for deemed variations, and deemed variations usually arise where there's some sort of weakness or discrepancy within the contract documents. But these are important. So looking at the standard building contract, JCT 2.14, it says that if in the bill of quantities there is any unstated departure from the method of preparation, so if you depart from the standard method of measurement, or any error in description or quantity or omission of items, that will be deemed to be a change. Or if there's an inadequacy in the employer's requirements and the contractor is not responsible for rectifying it, that will be deemed to be a change. And these things will be treated as a variation, and of course, you're entitled to price it as a variation. So there are these deemed variations which you need to be aware of as well. Very importantly, in Section 5, the variations section, it deals with substantial change to conditions of working. You'll be entitled to re-rate for a substantial change in conditions. And that would apply not only to where the works themselves are varied and they're done under a substantial change in condition, but where the work which is varied has a knock-on effect on other work, and that work has to be done under a substantial change in conditions, then you can also charge for a re-rate for that knock-on effect to other work which is done under substantially changed conditions. So that can flow through the contract and entitle you to a major re-rate. Generally speaking, there is a principle called the inclusive price principle, and that says that all work reasonably necessary and incidental is included in the price, whether specified or not, whether that is specified or not. That general principle doesn't always survive these very complicated modern contracts, but what you will often see is that that will be built into the preliminary section. So the employer in the prelim section of the contract will say all works reasonably necessary and incidental are included in the price, whether specified or not. So beware of that. So what's the procedure for instructing and requesting and confirming changes? Well, generally under JCT, variations need to be communicated in writing. And it's the same under the design and build as under the standard building contract. If we look under the design and build contract, if the employer, this is 3.7.2, if the employer issues an instruction otherwise than in writing, it's of no immediate effect. But the contractor then has to do what we call a CVI, a confirmation of verbal instruction, within 7 days. And then if the employer doesn't dissent from that within a further 7 days, that will be binding on the employer. If neither party confirms the instruction, but the contractor complies with it, then the employer can confirm it retrospectively at any stage up to the final payment. But from the contractor's point of view, you don't want to be going along crying towards the end of the contract, please confirm the instruction. You need to have confirmed it on CVI within 7 days. Have you got to comply with instructions as a contractor? Yes, basically you have. And you can see that that is a major risk. Contractor carries all these risks in the ground, etc. But on top of that, he can have a £500,000 contract that becomes a £3 million contract, and he's not allowed to walk away. And before you ask the question, how big does a variation have to be before it blows away the contract? It would have to be massive. That is generally the case law. It's very, very exceptional that you can walk away because of a change which destroys the entity of the contract. So you do have to comply with instructions with limited exceptions, and they are, so we were talking about the second part of the definition of variations, changes to sequence, hours, space. That second part, if you get an instruction under that second part, then you can give notice of reasonable objection. So under 5.1.2, you could give notice of reasonable objection. And that is very, very important. And on a hospital project, I had a contractor say to me, thanks for your advice, Philip. If I'd known that I could give notice of reasonable objection, I would have saved myself £500,000. So it can be as serious as that. Under a design and build contract 3.8, the contractor can say, I don't recognise where this instruction comes from, tell me what provision of the contract it's issued under. Then the employer has to reply and say, if the contractor doesn't challenge that, he will be bound by what the employer has said. And under the JCT contract, very importantly, an employer may not affect a change if it changes the design, except that the contractor then has to consent to it, and his consent is not to be unreasonably delayed or withheld. I mean, he doesn't have to consent to it. If he thinks it's a bad change to the design, he can notify that. But the contract is saying that his consent is not to be unreasonably delayed or withheld. Penalties for non-compliance, well, basically a 7 days notice will be issued to the contractor to say, comply with this instruction we've given you for the variation. If he doesn't comply within 7 days, the employer can take that work off him and give it to other people and contra-charge him for any expense that he incurs. And so you can be given a 7 day notice to comply, and also not carrying out an instruction is a ground for termination under the contract. One point to make is that in relation to omissions, although omissions can be made and they can be pretty big omissions, what the employer can't do is to take the work off the contractor to give it to another contractor for his benefits, let's say at a lower or cheaper rate. And that would be regarded as a fundamental breach of contract because he's cherry picking the bargain, and that would entitle the contractor to terminate the contract or accept a repudiatory breach of contract. The case on that is an Australian case from the 1950s, Carr, C-A-R-R, and Berryman. Variations in time, well, I'm sure you know that a variation will be a relevant event. You must notify relevant events under the time mechanism of the contract. So under the Standard Building Contract 2.29, variations or changes to be treated as variations must be notified as soon as reasonably practicable, stating the effect and the delay, and then you follow up. If that continues to affect you, you follow up continuously notifying the effect. You should identify the effects on programme, and if you possibly can, have a critical path analysis so that you can show how it's affecting you. The contract doesn't say that, but that would be very helpful. And then variations and valuation. there is a huge section in section 5 which deals with the proper valuation of variations. Go to the valuation of variations section at 5.6 and follow the regime. I'm not a quantity surveyor, so just advise you to do that. But you will be entitled to claim for time-related preliminaries. As I've said, you will be entitled to claim for substantial changes in the conditions of the varied work or other knock-on work physically altered. Almost everything is measurable under the JCT. So I was told many years ago by an old quantity surveyor, that's the way the JCT operates. The idea is that you should be able to measure anything under the JCT. Loss and expense should be treated as a small dustbin to the side where you can claim for disruption for things that simply aren't measurable. So if you had 2 gangs of men standing because somebody lost the keys, there's no measurable work being done. That's a classic example of loss and expense, where as long as you can prove you had those men there, you can claim that as loss and expense and prove your cost. But in most situations, you're better off with 2 QSs on either side, valuing and measuring the thing, and that's what the JCT allows you to do, to measure variations. So very wide definition of variations and detailed provisions for their valuation under the contract. So I hope that's been helpful to you, ladies and gentlemen. Second of our LawBytes takeaways. That's it from me. Thank you very much.